The ex parte meeting was at a critical stage and violated Kendrick's right. Now, this is the biggest part that I think we all disagree with. The defendant argues that on June 10th, the ex parte meeting was at a critical stage and violated his rights since he was not permitted to be present. Even with every single thing that's going on in this crazy trial today, with Woody saying he's going to testify, with the jury deciding that they're going to be able to disregard all the information that they heard between the 12th and the 14th, we have another denied motion coming from Judge Whitaker. So she's still putting in the work over here. So check this out. Which motion was denied? We're going to get into it here in a second. This is the state of Georgia versus DeMonte Kendrick. Y'all know who that is, aka Yak Gotti, represented by Doug Weinstein. This is Judge Whitaker's response and her order denying defendant Kendrick's motion for mistrial and supplement to the same. Now, in this supplement, you may remember that Mr. Weinstein said one of the reasons that he wanted a mistrial is because the jury is going to have a really hard time disregarding the testimony that they've heard from Lil Woody. And he used the reference, or he used the analogy of, if you tell somebody to not think about flying elephants, that they're going to think about Dumbo. You just can't help it. When somebody tells you not to think about something, you think about it. But Judge Whitaker was very smart with her wording, and she didn't ask them not to think about it. She said, just disregard it. So if that, to me, that says, if that thought comes to your mind, just put it out of your mind and keep moving forward. That's what that says. But moving forward, what did Judge Whitaker say? Before the court is defendant Kendrick's July 23rd, 2024 motion for mistrial supplemented on July 31st, 2024. The court has also considered the state's response, oral arguments by the parties, the transcripts of the June 7th and June 10th, 2024 ex parte proceedings, and the applicable law. The motion for mistrial asserts 3 grounds for mistrial, which the supplement asserting a related 4th ground, that it is impossible to redo the process that occurred on June 12th, 13th, 14th, and 17th before the jury. In the interim between defendant's June 12th, 2024 motion to recuse the predecessor judge, Judge Glanville, we know, and his ultimate recusal. 2, that the defendant's constitutional rights to be present at a critical stage of the proceedings was denied when neither he nor his counsel were present for the June 10th, 2024 in chambers on the record ex parte discussions amongst the court, prosecutors Love and Hilton, counsel for Lil Woody, and Lil Woody himself, not to mention Officer Long, who was there and said, yeah, Lil Woody didn't say those things, but we're just going to leave him out of this. The defendant's number 3, that defendant's due process rights were violated when Judge Glanville aligned himself with the prosecution team by his comments during the June 7th in court on the record ex parte discussion between the court and prosecutors Love and Hilton, and allegedly coerced Lil Woody into testifying during the June 10th ex parte meeting. Jury's still out on that, pun intended, but we've talked about this several times on the show. I think we all agree that Judge Glanville was using coercive language, but we're not a judge. We're just regular people who would like to have the court do the right thing. Judge Whitaker is making her decision. And number 4, as raised in the defendant's supplement, that bias of the Judge Glanville constitutes due process violations of defendant's rights under the Constitution of the United States and the state of Georgia. Yak Gotti also asserts that the motion for mistrial was goaded by the state when it requested that Judge Glanville hold the June 10th, 2024 ex parte meeting, which has been the subject of much discussion in this case. Absented Yak Gotti from the meeting and joined with Judge Glanville in the coercion of Lil Woody. Impossibility of addressing or redoing the proceedings post June 12th, which are void. Okay, this is what she asked the jury this morning. She said, hey, are y'all going to be able to disregard everything they heard? And they said, sure, I don't have a problem with that. Defendant Yak Gotti raises issues that the court has already addressed in granting Young Thug's motion to invalidate and strike all proceedings and occurred in the above referenced case on and after the initial motion to recuse Judge Glanville was filed on June 12th, 2024. As noted, the order granting defendant Young Thug's motion, the court had been working with the parties on which testimony and evidence should be resubmitted, represented to the jury in this case, and whether any other evidence at issue will be stipulated to as well any needed rulings and instructions related to the same. And she says the order granting defendant Young Thug's motion noted that the court would work with the parties, and since that time, the court has done just that, formulating instructions and addressing evidentiary issues with the input of all parties. Okay, let's keep going. As such, the court does not find that there is an impossibility of addressing these issues, and therefore there is not a basis to grant defendant Yak Gotti's motion for mistrial on these grounds. The June 10th, 2024 ex parte meeting. We've heard so much about this. I'm not going to go through it again. We already know her stance on this. She basically says there were no violations, that this meeting was allowed to take place, and the defense did not need to be there because it was about his immunity and about him being held in contempt, not about the trial itself. We all disagreed. We also found out Judge Whitaker decided there was no Brady evidence found during that meeting because Kayla's testimony was inconsistent. But Officer Long got up there and he said, I didn't hear any Brady, didn't seem to be any Brady. And whatever Kayla's saying, he said, I was right next to them and I didn't hear it. So Judge Whitaker said, we're going to move on from that. The meeting was appropriate. The ex parte meeting was at a critical stage and violated Kendrick's right. Now, this is the biggest part that I think we all disagree with. The defendant argues that on June 10th, the ex parte meeting was at a critical stage and violated his rights since he was not permitted to be present. A critical stage is one in which the defendant's rights may be lost, defense waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. And then we've already went over that several times. And she said this in past motions that she's denied as well. Judge Glanville improperly coerced Lil Woody to testify, separate from any defense rights to be present for ancillary proceedings concerning witness immunity. Defendant has a right to a free trial, trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and Judge Glanville to Lil Woody about the law of derivative, use immunity, the applicable statute of limitations relating to what crime or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Lil Woody into testifying. Which, I mean, how is that not true? And isn't it up to his attorney to clarify these things to him? Why was he getting legal advice from Judge Glanville? We still haven't been explained that, because that's exactly what Judge Glanville was doing. Here, Lil Woody had the benefit of counsel. I mean, we didn't hear counsel say much. Again, no offense to Kayla Bumpus, but she asked some interesting questions about what type of evidence could come into play if he were to testify and say certain things. But that was pretty much all we heard from her. The whole time, the transcript just shows Judge Glanville and ADA Hilton giving Woody some advice and their own thoughts. Here, Lil Woody had the benefit of counsel. Judge Glanville did not on the whole use intimidating rhetoric, but rather sought to ensure that Lil Woody understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Lil Woody were not his to make, but were up to the prosecutors. Still, some of the information provided to Lil Woody may have been inaccurate. What? Apparently, to Judge Whitaker, that's not a big deal. Bias on the part of Judge Glanville constitutes due process violations. Based on the comments in the ex parte transcript made by the Judge Glanville about counsel, both for the defendants and for Lil Woody, as well about outside agitators, defendant asserts that the Judge Glanville during this conference revealed his partiality to the state. I'm going to mess up this word, but Pretermitting. Oh man, gosh, I'm sorry, y'all. I don't know that word. They be throwing all these words at me. I'm building my vocabulary though. The questionable inaccuracies of the characterizations and or discussions. This issue has been mooted by the recusal of that judge from this case. Wherefore, for all of the foregoing reasons, Yak Gotti's motion for mistrial and supplement to the same are hereby denied. Okay. Judge Paige Reese Whitaker. So there it is. Y'all gotta let me know what you think. Did Judge Whitaker again make the right choice? We heard in court earlier that Yak Gotti's attorney, Doug Weinstein, is going to renew his motion and try and push for a mistrial again, based on the fact that Woody is testifying and he feels like that he was coerced into testifying. And Lil Woody stated that as he was letting Judge Whitaker know that he was going to go back on the witness stand. So we'll see what happens. I want to know what y'all think. Is this going to move forward? Is just Whitaker going to say the same thing and deny it again? We'll have to wait and see.